Pavarotti.
Pavarotti?
Of Pavarotti.
He gives me chills.
Let's listen to Pavarotti.
Hello, welcome to The Revealing. I'm your host, Pavarotti, here to give you an update on the Idaho 4 case. In this episode, we're going to cover the new docs that just dropped and see what we can glean from those. And we'll also take a look at the case summary so we can see all of the things that we'll be posting here soon. And we see a few pleasant surprises as we look at that case summary. But first, let's go through the few docs that actually did post. Of course, they're under seal, but whenever they put them under seal, they always add us a little caveat in there, and we will look up the Idaho criminal rules on the caveats that they give us just to see what we can decipher from them. So let's roll into it. Okay, so here's our first one, and you can see it was actually filed on December 13th, but this was that Defendant's 20th supplemental request for discovery. It is finally posted. Please take notice that pursuant to Rule 16 of the Idaho Criminal Rules, and then we talk about all the amendments to the Constitution, but let's see, the state of Idaho requests discovery and inspection of all materials discoverable by defendant per ICR 16B 1 through 8 and the aforementioned constitutional provisions, including but not limited to the following information, evidence, and materials outlined in Exhibit S. Exhibit S will be filed conventionally in person under seal on December 13th. Of course, we don't get to see Exhibit S, but considering the Idaho Criminal Rule 16B has more than 1 through 8, there's actually about 13 rules. We need to jump over there and just see which one of these 1 through 8 really gives us the relevance of this discovery and see what we can try to comprehend from the Idaho Criminal Rule that relates to what they're looking for. Let's take a look. Okay, so here we have Idaho Criminal Rule 16, and it said B, which is right here, 1 through 8. But 16B is disclosure of evidence and materials by the prosecution on written request. Except as otherwise provided in this rule, the prosecuting attorney must, at any time following the filing of charges on written request by the defendant, disclose the following information, evidence, and material to the defendant. So that says must. They must do it. And number 1 would be the statement of defendant. On written request of a defendant, the prosecuting attorney must permit the defendant to inspect and copy or photograph A, any relevant written or recorded statements made by the defendant in the possession, custody, or control of the state, the existence of which is known or is available to the prosecuting attorney by the exercise of due diligence, the substance of any relevant oral statements made by the defendant, whether before or after arrest, to a peace officer, prosecuting attorney, or agent of the prosecuting attorney, and the recorded testimony of the defendant before a grand jury that relates to the offense charged. Now, it says in the prosecution's reply, which they haven't posted that yet, but it says in that reply that this discovery relates in some way to expert witness testimony. So even though this relevant written or recorded statements before or after arrest, we could say could be relevant because one of the motions to suppress was suppressing statements that the defendant may have made. So that tells me the defense doesn't have discovery of any statements that he had made that they were going to use against him, but we know that they're trying to suppress any evidence that may have been said to the arresting officers as it relates to was anyone else arrested, is what I'm trying to say. But because the prosecution put in the reply to this that it's the defendant's expert witness testimony that it relates to, I don't think that one's going to apply. And then number 2, we got statement of a co-defendant. On written request of the defendant, the prosecuting attorney must permit the defendant to inspect and copy or photograph any written or recorded statements of a co-defendant and the substance of any relevant oral statement made by a co-defendant, whether before or after arrest, in response to interrogation by any person known by the co-defendant to be a peace officer or agent of the prosecuting attorney. Again, with this being related to expert witness testimony, I don't think that one applies. Defendant's prior record. On written request of the defendant, the prosecuting attorney must furnish the defendant copy of the defendant's prior criminal record, if any, if it is then or may become available to the prosecuting attorney. Again, that doesn't relate to expert testimony. I don't think that pertains. Documents and tangible objects. On written request of the defendant, the prosecuting attorney must permit the defendant to inspect and copy or photograph any books, papers, documents, photographs, tangible objects, buildings or places, or copies or portions of them that are in possession, custody, or control of the prosecuting attorney, and that all are material to the preparation of the defense, are intended for use by the prosecutor as evidence at trial, or obtained from the defendant to or belong to the defendant. Again, I don't see how that would relate to the expert testimony, so I wouldn't think that would apply. This one, I think, would probably be it. Reports of examinations and tests. On written request of the defendant, the prosecuting attorney must permit the defendant to inspect and copy any results or reports of physical or mental examinations and of scientific tests or experiments made in connection with the particular case that are in the possession, custody, or control of the prosecuting attorney, or the existence of which is known or is available to the prosecuting attorney by the exercise of due diligence. I think this is the one that would apply if it relates to the drive test data that Cy Ray, specifically on the stand, an expert witness, said that the defense didn't have and that they needed. So my guess is the 20th motion to compel discovery is for the drive test data. And for those of you that don't know, the drive test data is what the FBI, they take a machine and they drive through all the relevant areas, and it records how the cell towers react to specific areas of the drive test so that they can verify if what they're looking at is correct when they try to pinpoint accuracy of location through the CAST data. And during one of the hearings, Cy Ray specifically said they had no drive test data for Highway 270, which is Main Street that connects Pullman to Moscow, and they didn't have any drive test data on the actual residence, the King Road residence itself, which would both be the two most pertinent drive test data places to have. And then number 6, because they said through 8, state witnesses. On request of the defendant, the prosecuting attorney must first furnish to the defendant a written list of the names and addresses of all persons having knowledge of relevant facts who may be called by the state as witnesses at the trial, together with any record of prior felonies of any of them that is within the knowledge of the prosecuting attorney. The prosecuting attorney must also furnish on written request statements made by the prosecution witnesses or prospective prosecution witnesses to the prosecuting attorney or the prosecuting attorney's agent or to any official involved in the investigation of the case, unless a protective order is issued as provided in subsection L of this rule. So I don't see how that would pertain to expert witness testimony, but very interesting. Expert witnesses. On written request of the defendant, the prosecutor must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rules 702, 703, and 705 of the Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. Disclosure of expert opinions regarding mental health must also comply with the requirements of the Idaho Code. The prosecution is not required to produce any materials not subject to disclosure under subsection G of this rule. The subsection does not require disclosure of expert witnesses, their opinions, the facts and data for those opinions, or the witnesses' qualifications intended only to rebut evidence or theories that have not been disclosed under this rule prior to trial. That's interesting. And then finally, police reports. On written request of the defendant, the prosecuting attorney must furnish to the defendant reports and memoranda in possession of the prosecuting attorney that were made by a police officer or investigator in connection with the investigation or prosecution of this case. So that one's interesting. If you watch Truth and Transparency's video that she did today, they were discussing how they added Kohberger as a person of interest to a case that happened 10/10 of 21 in Pullman, and they added his name as a person of interest after they arrested him in 2023, and that could apply to that case, but I don't see how it would. I don't see how it would be relevant as far as expert witness testimony. So either something in number 7 here, or my guess is, like I said, number 5, reports and examinations of tests, is what that is pertaining to. Let's go to the next one. Okay, now we've got a stipulated motion to seal state supplemental response to request for discovery regarding expert testimony. And this is just the state responding to what the defense filed. Now, one thing that they do cite in their response is 32G1, and they actually cite it twice. So let's take a quick look at 32G1 to hear their response argument. Okay, so here we are with Idaho Court Administrative Rule 32. So we need 32G1. Let's go down to G. Let's see, that's E. There's a lot in E, isn't there? Oh, wait, no, that is G. Hang on, that was H. Let's see. Okay, 32G1. Documents and records to which access is otherwise restricted by state or federal law. So, documents and records to which access is otherwise restricted by state or federal law. The court records exempt from disclosure. Except as provided in the paragraph, this rule, court records specified below are exempt from disclosure. Any willful or intentional disclosure or accessing of a sealed, shielded, exempt court record not otherwise authorized under this rule may be treated as a contempt of court. And that includes documents and records to which otherwise is restricted by state or federal law. Now let's go back to their argument. So it says, prosecuting attorney hereby moves the court pursuant to Idaho Court Administrative Rule 32G1 and Idaho Code 74124 for an order sealing state's supplemental response to request for discovery. Okay, so that is just what they're citing as far as sealing the response, and their response is all sealed. Okay, so nothing to see there. And then again, we've got their stipulated motion to seal states, stipulated motion to seal states' motion to extend no contact orders and amended no contact orders. And once again, they're just going to cite Rule 32G1 and give the same argument for the sealing and not give us any information on what it actually is. So those are the 3 docs that posted. But now let's take a look at the case summary, and I'm going to show you some cool stuff. Okay, so here we are with the case summary, and you can see on December 11th, that was that secret motion hearing. And since then, the defense on the 13th filed their supplemental request for discovery, and they stipulated to the prosecution to seal the state's motion to extend the no contact orders. And the no contact orders I went over with you in a video yesterday. But since then, because it didn't list Miss Miss Mama here, Miss Kernodle, in any of these no contact orders. I went all the way back to the beginning because I know for a fact, I've looked at it 100 times, that Miss Kernodle was in a no contact order in the beginning of this case. And now it is nowhere to be found in those either. So I think that is very weird. They not only didn't extend it, but they removed it from the case summary. I mean, there's no contact orders, and there's no victims rights in here for her. There's nothing in here about her now, which is very strange. But you can see here on the 18th, stipulated motion to seal, state's motion to extend the no contact orders. That's what we just read that posted. And then there's the motion that's going to be sealed to extend the no contact orders, all the no contact orders. But then we've got a stipulated motion to seal state supplemental response for discovery. That's what we just went over. And then that was the response that's sealed. And now reply to memorandum. This is from Ann Taylor on all the motions to suppress objections from the prosecution. Reply to memorandum. Reply in support of defendant's motion to suppress and memorandum in support of the arrest ID in Pennsylvania. So that will be posting soon. A reply to the state's objection for the motion to suppress in support of the Lambsden statements. That will be posting soon. Reply to the state's objection to defendant's motion to suppress in support of Amazon. Now, looky here. No motion to seal, no stipulated seal. So that means that reply to that objection the state filed under seal is going to not be under seal. So we'll be able to see her reply and be able to see what the heck the state's objection was they didn't want us to see. So thank you, Ann Taylor. You gave us a Christmas gift there, I'm sure. And this one is her reply to the motion, to the memorandum in support of Apple. And this one right here was filed under seal as well. And that's the reply to state's objection to motion to suppress cell phone USB file and memorandum in support. This is the one that cites in the state's sealed objection something about the Moscow evidence room. So we're going to get to see that. And then she also replied to the state's objection to defendant's motion to suppress the first AT&T warrant, the most important one. Memorandum in support of Google. I believe Google was the other one we weren't going to get to see. And then I know the pin trap and trace for some reason was one we weren't going to get to see. There's no stipulated motions to seal. We're going to get to see all those. And then there's also a motion for leave to exceed page limit. Now, that's awesome because remember before when she filed the motion for the Franks hearing, she exceeded the page limit in the motion. The prosecution filed an objection. The judge overruled it and said in the future, make sure you ask for leave first. Well, they're following his procedure to a T, so they asked for leave of page limit first in whatever motion this is, and good job, defense team, following instructions. Response to request for discovery, that is the prosecution's response to that request for discovery. Stipulation. Stipulated motion to file replies to state's objection to Franks and IGG under seal. Okay, so this one is the one I said I knew we weren't going to get to see because they didn't let us see the original motion. So we got a stipulation on the motion to file defendant's reply to state's objection to Franks and IGG under seal. Good job. And then the replies under seal for the replies under seal for the genetic information. Reply to state's objection, amended motion, memorandum support of Frank's hearing. So this right here is going to tell us a lot, by the way, and I'll explain it here in just a minute. All right, and everything else is not changed, but the fact that they filed for the Franks hearing, they have a reply here to the state's objection to the genetic information and the Franks hearing, tells us something. What does it tell us? Okay, we're going to put our thinking caps on now. On December the 11th, there was a secret hearing scheduled after Ann Taylor filed the Franks motion. We know that, I can tell you now unequivocally, that there has not been a hearing on the Franks motion at this point. And I'll tell you why in just a second. However, it tells me that that secret hearing was a hearing on granting the hearing for the Franks motion. And folks, the hearing for the Franks motion is going to be held, I assure you, on January 23rd when they do the rest of the suppression the rest of the suppression motions. And here's why I say that. The judge must have granted the right to be heard in court for that, because if he hadn't, there would be no need for the state to object to it, and there certainly would not be a need for the defense to reply to the state's objection to it. The only thing left to do is oral argument. You can bet it will be on January 23rd because that was the pre-scheduled hearing for all of the ICR motions, which include motions to suppress. At this stage of the game, the only way a Franks motion comes into play is if it relates to a motion to suppress. So you can bet the first part of that hearing on the 23rd is going to be to hear the Franks argument to get the first AT&T warrant suppressed under Franks, which will then make the rest of that hearing very, very interesting. But I think it'll be interesting anyway. But hopefully that's as clear as, hopefully it's not as clear as mud. I want everybody to be updated as much as possible. Boy, just sentences running together. Doing too many videos. The last one of the day, I assure you. I do have a really good one for you tomorrow, though, as it relates to why they were searching for Kohberger. But that's where we're at. Hopefully on Monday or Tuesday, they'll actually post those replies and we can pick some fly shit out of black pepper on those bad boys and figure out some other stuff that we need to know on this case. But until then, please like and subscribe to the channel. Post your comments, thoughts, your criticisms, and until next time, let's see. Pavarotti's out.